Please, Your Worship.
Yes.
Worship, I am senior general private respondent number 7, Your Worship. Was allowed to work as assistant in charge, Your Worship, in charge administrator. Total 5 years, 10 months, 8 days, and kindly see page number 12, Your Worship.
PTC,
Yes, I am.
any instructions?
Instructions. Lordship. Some accommodation, Lordship.
Third counsel for parties, because private respondent is there. Private respondent is there, we have to issue notice.
Notice my God.
Third counsel for parties issue notice. So, Shari,
Worship, we have submitted several recommendations, Your
Yes.
Worship, that also pending. Your Worship.
for respondent number 3,
3, 4, 5,
3,
7.
4, 5, 6, 7. MSCTI appears for respondents 1 and 2. Therefore, notices on behalf of respondent 1 to 7 stands waived. However, extra copies be furnished within a period of 1 week. Steps of respondent 8 by speed post within 1 week. Released after
The date is the
7th of September.
Obliged.
So, come to page number 24, madam. The petitioner was funded as headmaster with all full scale on 31/2024. And after 12 months, without any proposed notice, next page, minus page 25, that has been cancelled. And he is the only teacher of the particular school with MA and BA. The person has been written on appointment either just a BA.
Private number, private respondent
Private respondent.
is appointed.
He is appointed, he has only the qualification of BA, not even qualified to.
No, presently she is the in charge.
Only
Right. Council for parties is written every 4 weeks. HR Das for
For respondent number 1, 2, 4, and 5.
1, 2, 4, and 5. Who's for
One.
3? Mr. Reyes Borua for respondent number 3. For notices on behalf of respondents 1 to 5 stands waived. Extra copies be furnished within a period of 1 week. Steps on respondent 6 by speed post in 1 week.
Only interim period means that no permanent teacher should be appointed in that particular thing. One of 5 is appointed in charge. Someone appointed in a permanent.
But that will have to be undertaken by the process.
The thing is that no permanent teacher.
Permanent headmaster will have to be appointed by a process, by advertisement, etc. All these steps will be taken. No steps have been taken.
Yes. Pension has been wrongly fixed.
Pension.
Paid for revision, my lord, but that has been denied. Against that, my lord, I find this. Notice may be issued.
Third council for parties issue notice. Speedas appears for respondent 1,
1, 2, and 3.
4, no, 1 to 3.
1, 2,
Ms.
3.
Kumar appears for 4. Ms. Hazarika for 5 and 7. Huh? Okay. Who's for 5? 4 and 5. Directorate of Pension. Yes.
4.
4 and 5.
7. Hazarika and Sharma for respondent number 6. The respondents are represented. List after the return date.
Deeply organized.
Yes. List next week. Anyone for the government? There is this Sharma. Yes, one. Respondents to me.
1, 4, 5, 5 and 6.
S Kumar for 1, 4, 5 and 6, then S Sharma for 2 and 3.
No, was it headmaster in the school, was placed on the suspension on his being arrested in a police case. Was released on bail. And since the police case was not in connection with his service or other thing,
He is still under suspension.
he is still under suspension. So
Yes.
it was given, I have given so much notice, no inquiry, nothing, Malad, is being kept.
Yes,
this time it is
elementary
very-
education,
BTC,
BTC.
thank you.
Who's for BTC? Yes, Mr. Musari, get your instructions. Why are you keeping this man under suspension since the year 2025?
Yes,
What is the status? Please get instructions.
Yes, Doctor. Although I show for instruction, I will take instruction.
See if you can get instructions without issuing notice.
Yes.
Yes,
Then we
yes,
can-
Lord. On the next,
Mr. DP Chalial and Senior Counsel, assisted by Ms. M. Roy.
Yes.
And Mr. N.C. Musari, appearing BTC authority. The petitioner is agreed by the suspension order,
2, 3, 4, and 5, Lord.
prolonged suspension, which the petitioner has been subjected to since the date, since the order of suspension dated 8/12/2025,
2020.
although any show cause issues,
Yes, Malad.
show cause was
The
issued,
case
to
that the
which
head-
petitioner filed the reply. However, no final order has been passed, nor has the suspension been removed. You agree? Present time. Correct. At this stage, we permit the standing counsel BTC to obtain instructions as to the status of the proceeding initiated against the writ petition, and as to whether the order has been passed revoking the suspension of the petition. Stop. No, notices are not issued, the extra copies will be furnished within 2 working days to enable him to obtain instructions. Release this matter again for 17.
1 please.
17.
7.
Okay.
Yes.
Actually, this case by the petitioner has already completed more than 20 decades of service in Assam Engineering College Library minor. Whatever minor, this is not a casual worker minor, his regulation has not been considered. Also, kindly turn to page 19 minor, 17 minor, 17 and 18 minor, his qualification certificate minor. He has completed the master degree. Thereafter, what happened minor, due to the acute shortage of the human resources in the college minor. In the year of 2005 and 2006, minor authority has engaged 30% along with the petitioner as a casual worker. At the very preliminary stage, minor, they were considered as the daily wage earner. Later on, minor, they were considered as the casual worker. And in this regard, my lord, kindly turn to page 19, Annex 3 series, my lord. There is so many year by year, my lord, the principal provided the experience certificate till 2026. That 26, lordship will find at page 26, my lord. My lord, he is still working against the in the central college library in the Assam Engineering College. And at the initial stage, my lord, he was paying only 2,000 rupees, my lord. His pay bill, my lord, I have annexed at page 27, my lord.
Will issue notice here.
Notice, my lord, in the meantime, my lord, I may not be disturbed, my lord, because I have already completed the 2 decades of service, my lord.
You are still serving.
Still serving, my lord.
Was the lordship involving the internal arrangement of the college?
Yes, my lord.
So he is
Right. Mr. Boardway, the council. The party identification. The respondents. 1 to 4 or 5 also.
I did the government college.
The respondents. Petitioner is agreed by non-consideration of his prayer for regularization in the post of Librarian.
Technician of library.
Huh?
Assistant technician of library.
Assistant technician of library in the Assam Engineering College. So, petitioner is rendered more than 2 decades of service. In spite of that, his services have not been regularized. They agreed he has abused his court that notice issue, which are 4 weeks since the respondents are represented. So the way the extra copy is furnished within a week. The apprehension expressed by the petitioner that his services may be terminated till the next returnable date. Services, no order be passed adversely affecting services of the request.
Right.
Release this matter on 7th of September.
Obliged. Madam, my post is library technical assistant.
Library technical assistant in the Assam Engineering.
Obliged.
My lord, petitioner husband has expired on 8/2/2026, and she is entitled to compassionate family pension. She has submitted a presentation that has not been considered.
Yes, instructions, anybody? Who's for the respondent?
We have not received any instruction notice.
No, you will not, because this come for the first time. You have
Yeah,
not
yes.
issued notice.
Yes.
Would you like to obtain instruction
Yes, yes.
without issuing notice?
No, no.
Notice has to
Notice
go.
is good.
Third council for passing issue notice. Return of 4 weeks. Mr. Chisti. Learned council appears for
I am for 1, 2, 3, and 4, Lordship.
1, 2, 3, and 4. MSS Scorn for respondent number 5. MS Azoriga for respondent 6. Since the respondent they represented. If extra copies be furnished within a period of 1 week. Released after return building.
That may be fixed by the family pension.
7th September.
Pendency shall not be a permanent.
Pendency of the writ petition shall not be a bar to redress the expansion of the
Obliged.
Pertaining to the increment to the petitioner, madam. They were appointed before 2010, my lord. Thereafter, BF degree was my lord taken, my lord. Then, my lord, similar petition, your lordship dispose of, my lord. Page 38.
similar.
Yes, my lord.
Where
Page 38.
38.
Yes.
Let him examine it.
Yes,
Lordship.
When can you do it? Wednesday.
Yes, Lordship.
For today.
For today, it's
Huh?
for today.
Today.
At 2, Lordship.
At 2 p.m.
At 2 p.m. I will examine.
At 2 p.m. let him examine whether it is
Yes,
covered.
yes.
yes.
At 2 p.m.
This matter we are paying for a similar order, madam. Is starting 252, madam.
52.
252, madam.
252.
Yes, operating part is start, madam, 254. And petitioner is a grade 4 employee, madam, receiving 6 scale of pay, madam.
What is the direction here?
Madam, in this time, give the direction to submit the representation before the older respondents and consider their case within 8
Where
weeks.
is the decision of the division bench?
Division bench order, my lord, will find at operating part 246, my lord. And concern paragraph, my lord, 9 and 10, page number 248. my lord.
Yes, Mr. Mushari. We'll have it on Monday. You go through and tell us. Monday. released on Monday, enabling the standing council BTC to examine as to whether the prayer made by the petitioner that the matter can be disposed of in terms of WPC's will. Whether the issues raised in the petition are instead covered in terms of the judgment of the writ appeal, being writ appeal number so and so, and also WPC number so and so.
Supplementary promotion, I think 92.
Yes.
Connected cases are fixed on 24.
Huh?
Connected cases, connected cases are fixed on 24 of August. Is related to termination of OB teachers number installed.
I heard Learned Council for Parties issued notice returnable on 24 of August. As is submitted that similar writ petitions are fixed on the same date. Mr. P. N. Sharma appears an exception notice on behalf of elementary education. Appearing for respondents number 1, 2,
3 and 4.
3 and 4.
I'm sorry, Lordship. 4 is
1, 2,
1,
3.
2, and 3.
Mr. Musari appears for respondent number 4 and Ms. S. Kuan for respondent number 5. Since the respondents are represented, notices are waived, extra copies be furnished within 3 working days. Matter be listed along with WPC
3841-2026.
3841-2026.
I think we. Hello.
Yes.
Earlier, the petitioners were working as in a Bengali medium schools as a Bengali teacher. Now, earlier also he was transferred to a non-Bengali school. Then this noble he approved this noble court along with similar other persons, and this noble court person order is also expressed to decree. Comparative expressed 24.
Page number 24.
24. And there is a one OM at that point of time. And a matter is referred to the DLC.
What order is this? What is the DLC? District level
The
committee?
district level committee.
Yes. Who's for the respondents?
Here for respondent number 3, the Deputy Commissioner Dhubri,
Who's for the education department?
education,
Elementary.
elementary.
Who's for elementary education?
I think very good.
Where is the order of transfer?
25 please.
25.
My name is FS serial number 6. And in my place, serial number 3 has been.
No, is there any rule that says that you cannot be transferred otherwise?
That is a
Exactly.
but that when that it was there, but now one act has been passed. It is Act 2000,
What is this act for?
my lord, my lord, the Assam Elementary and Secondary School Teacher Regulation of Posting and Transfer Act 2020.
Assam Elementary.
Education, Elementary and Secondary School Teachers Regulation of Posting and Transfer Act 2002. In that said, my lord, clause 6. There is a provisions, my lord, and D, with D.
I don't know if this. Do you have an extra copy?
My lord, this is a book with. And I found there is no when now.
Fifth edition. These are both fifth edition, but the size is different.
My lord, this book is now new. It is a
New publication.
new book.
So what does it say?
Clause 6.
Clause 6, section 6.
Section 6, clause 6.
You are referring to 6C,
6D.
D. How is the PTR to be determined?
Pupils teacher ratio.
How is it to be determined?
Because well, in the school of the Sondra 7, there is a 176 now teachers. It is a SMS medium school, and there is a 4 teachers. And in my school, it is a Bengali medium school. 45 students are there.
And heard counsel for the parties issue. So you get instructions in. It's a matter of transfer. Do you want, if we issue notice, then
Short notice.
let issue notice returnable 2 weeks.
Not
MSS Kumar appears for elementary education representing respondent
1
1,
to 4 and 5. 1 to 4, 5, 6.
4, 5, 6. MSS Sharma for respondent number 3. Steps on respondent 7 by speed post within 3 working days. The petitioner is agreed by the impugned order dated 21/7/2026, whereby the petitioner has been transferred from the school in which he is working to transfer from the school in which he is working, namely Vivekananda Vidyapit, 2153 number Vivekananda Vidyapit, 2 TO2
Bengali medium.
Dokhin Khankoa Para LPS. Stop. It is the submission of the counsel to the petitioner that the petitioner is a teacher in a Bengali medium school, and he is the subject teacher of Bengali.
Not subject LP school, my lord. They all are Bengali.
Huh?
Medium school.
LP school, my lord. I am a head teacher of that school.
He is the head teacher. You are the head teacher.
It is, I am the senior most. Nowadays, senior most
He is the senior most teacher in the same school, and by way of this transfer, he is bound to lose his seniority, and also he is being transferred to an Assamese medium school. Stop. The submission of the counsel to the petitioner that the transfer, inter-school transfer is to be effected by the department in terms of the provisions of the Assam Elementary and Secondary School Teachers within bracket regulation of Posting and Transfer Act 2020, and more particularly in terms of section 6D, in bracket D. It is the submission of the counsel for the petitioner that this ratio has not been maintained and the petitioner has been transferred from without following the same ratio. Being agreed, he has approached his court the respondent councils are not posted with the required instructions. Therefore, matter is being listed on, directed to be listed on 17th of August. Till the next date fixed, the operation of the impugned order dated so far as the writ petitioner is concerned,
And
his
this-
name is
and this
listed
one
as
number-
serial number 6,
And this one number 7.
huh?
And this one number.
And respondent number 7 shall not be given effect.
Hello.
Yes,
We had asked for the records, they haven't come in as yet, although we filed the counter affidavit.
the records are necessary because what is directed?
Yes, that's directional. Lordship grants me one last chance. Place the records also.
So the only purpose for the records is to see that he has denied
Yes,
the government stand that the appointment was offered to him
and he refused.
and that he had refused. So he denies that this letter or any appointment order. Post, we'll give you another 2 weeks time.
Lordship, deeply obliged.
This taken on 19th August,
Deeply
by
obliged.
which time the record is called for be placed before the court by the government council. Mr. Arun Chaudhary appeals for the 19th August.
Master.
Obliged.
May I please, your Lordship? Lordship, Mr. P.K. Bora has some personal difficulty to the pilot. May we taken up the matter on Monday? Next Monday, my.
Next Monday,
Yes.
yes. On the request made on behalf of Mr. P.K. Boras, counsel, and custody brief. Matter stands deferred to be listed on Monday. Prayer made is not objected to by the council. List on Monday.
Obliged, Lordship.
Let it be on 19th, sorry, 5th. Not Monday, 5th. Wednesday.
Obliged.
We have already filed affidavit.
Readings are complete. What is the matter about?
I have filed Lordship. Five and six affidavit Lordship, because they are
They
at the-
submitted that the affidavits have been exchanged, readings have been exchanged. Matter be listed for admission after 2 weeks, a date to be fixed by the registry.
May I please, your Lordship? My senior, Mr. H. Gupta, he is out of state and we're seeking for accommodation for.
Any objection?
They were
Prayer is
supposed to
made on
file
behalf of
affidavit,
Mr.
Lordship.
H. Gupta, CDC, that the matter be deferred to be listed again after 2 weeks. Prayer made is not objected to be listed after 2 weeks. Yes?
They were supposed to file affidavit also, to
The
obtain some instructions.
respondents may file their affidavit if so advised after 2 weeks.
Okay.
Yes.
Yes, Lordship, 24, I am appearing for the sole respondent. So.
Review dismiss, whether they
Yes,
prefer review.
we have filed issue that are dismissed. Now the director has already written to the government for a proposal for Lordship. That will take some time, Lakshmi grant us some time. Though. Now review we have that has been
Where is the direction of the court? Page number 9.
Page number 9. Eight onwards, madam.
It is submitted at the bar that the review preferred against the order dated 10/6/2024 passed in WPC 2601 of 2023 has been dismissed. Review preferred by the state. Dismissed. Mr. Chisti submits that
Dismissed on 14/7/26.
dismissed on 14/7/26. Mr. Chisti, counsel appearing to the respondent to submit that he be permitted some time to complete his instructions with regard to the directions contained in the order dated so and so, passed in WPC so and so. Matter therefore be listed after 4 weeks, by which time the respondents are expected to comply with the order, failing which court may proceed to initiate proceedings under Contempt of Courts Act 1971, read with the Gauhati High Court's Contempt of Courts. After 4 weeks, 7th September.
Plus.
25 and 26 we have preferred review losses because losses here what happened losses that initially they were appointed under Adarsh Vidyalaya
You don't want to know why.
Yes.
You have filed a review. Review is pending.
review is pending loss.
Is it pending?
Lordship, my senior is at another court, which I
All right.
think you are-
Review is pending. That is submitted by the state. We'll
Review
take
is
it off
filed
the
loss.
record. It is submitted by Mr. SMT Chisti that the review petition has been filed. It's a common judgment.
Common judgment.
Common judgment.
Minor.
Against which 2 separate contempt petitions are filed. That a review petition has been prepared against the judgment and order dated 18 December 2024, passed in WPC 1916 of 2023. Therefore, the matter stands deferred to be listed again after 4 weeks. Parties are at liberty to apprise the court on the status of the review stated to have been filed by the respondents. After 4 weeks. You make a mention when the review is disposed of. You'll be able to find out because the review is there means you are also involved in the litigation.
Correct number D. Common order person. Common order person.
The record is with the big courses, but he is fell down in his home mind order, so that he got the injury mind.
Fell down.
Yes, logically. So the water he fell down from the first story to the ground floor.
Because of water.
Now he was wiping on water and he slipped, lost it in the staircase and he fell down it. And he located his arm, spinal cord or something. On 17th of take their other meter. On
With
17th.
the injuries you have described, you will not be able to come to court on 17th unless you want to make alternative arrangements. Anyway, we submitted that Mr. B. Kaushik, the counsel who had represented the respondents, enacted exposed at a proxy counsel this time. They made is not objected to by MSK Levy, the counsel for the petition. We list matter again after 4 weeks. 9th of September.
Whether restaurants are yet to file the affidavit. Not file the affidavit.
Why have you not filed the affidavit? There's some IA also.
Yes, no.
Filed by?
File the petition, not
For what purpose?
challenging the imping order at page 14 here also. Annexure 2.
To file affidavit.
Temporary by the imping order, temporary service of the petitioner is suspended in final disposal of the present petition. That has been stated. That is on the report. There are imping orders pending, continuing in both the IA and the petition.
You want to file affidavit?
Yes, but yes, but I would like to highlight it. It will be required. But the IA Lordship, the college response is because contractual appointment they have suspended. College response is the IA.
The IA, right? Counsel for Mr.
Arbor,
Arbora appearing for the opposite party,
on behalf of SP,
college, governing body,
R5 and R6.
behalf of the college authority, is permitted 3 weeks time to file his objections to the IA. The writ petition, the respondent higher education department is also permitted 3 weeks time to file their counter affidavit.
So interim orders to continue.
The interim orders passed in the IA
And the writ petition.
and the writ petition will continue till the next date, released on 28th of August,
Can it be in the month of September?
September.
Not
It's 7th September.
much of like.
My pleasure, Lord. So this writ petition is against the order of withdrawal.
Yes.
This writ petition has been filed against the order of withdrawal of one increment, my lord, without any disciplinary proceeding, without any inquiry, my lord. So basically, on 1/10/2012, SOCOS was issued. Thereafter, we made a defense statement on 8/10/2012. And
Affidavits are filed.
no, my lord.
Who is to file it? Higher education.
Elementary education.
Elementary.
Secondary education, my lord.
Secondary education.
Sometime maybe granted. File now affidavit.
Where is the impugned order?
My lord, at page 33.
33. Why don't we set aside this order and leave it open to the authorities to initiate? How can the inspector pass an order like this?
And in this regard, my lord, the deputy director has written a letter to the inspector of school regarding that matter, and he also requested, he is also directed the inspector to submit the detailed report along with the relevant documents.
No. You read the order, he is of the opinion the government servant is guilty. How can he pass an order like this? Is there any inquiry done by the inspector?
That is why, my lord, this letter has written.
When was this letter written?
10/7/2026.
Further 2 weeks time is granted to the respondents to apprise the courts as to why the impugned order dated so and so should not be interfered with as prayed for by the writ petitioner. Released on 17th.
Much obliged.
Mr. So-and-so appears for respondent number 5. You file an application before the registry.
Much obliged.
Lordship, in this case, already we have filed an IM
For?
striking of the respondent number 10. Since the petitioner who claimed as the assistant, the principal post against that particular college, he has already withdrawn from the claim and he has withdrawn from the writ petition.
Who is the respondent?
respondent number 10.
Respondent 10.
Yes. I'm appearing on behalf of respondent number 10.
So IA has been filed, my lord.
Respondent 10 is governing body.
Governing body, Sapekati College.
Oh.
And respondent number 7, this petitioner number 7, he claimed as the regular principal of that particular college. That process already been completed, new principal has come, and now he has withdrawn his claim.
You are appearing on whose behalf?
Respondent number 10.
So respondent number 10, what has got to do with petitioner number 7 not being the in charge?
No, since petitioner number was working in Sapekati College as assistant professor. And in that particular college, he claimed for regular principal. But regular principal already, the recruitment has been made, advertisement has been made, and already been appointed.
Okay, so these are principals, petitioners who are claiming principal in various colleges.
In the respective college.
How is it possible to club all this together?
My lord?
How have you clubbed all this together? Their claim is in respect of different colleges.
But the issue is same, my lord.
No, the issue may be same.
Subject matter and issue, my lord, is the same notification, same advertisement, same, my lord. Here, my lord, the arbitrariness and inequality, my lord, has happened.
All right,
against the,
if you
my
want
lord,
to
if
argue
your
on
lordship,
this, we will hear you on that.
my lord.
On the question of whether you can file a writ petition in this matter. How can you file a writ petition like this?
Because, my lord, the same notification, same subject matter,
But
different
against different
colleges,
respondents.
same respondents. my
How
lord.
can it be same? Governing bodies are different.
Governing bodies are, of course, different.
Then you're
But,
seeking orders against the governing bodies.
But director, secondary education, my lord, all these are same, my lord, the principal
That
respondents.
way, all writ petitions in the High Court can be clubbed together because director, secondary education, only one.
No, my lord, if subject matters are different, of course, my lord, there will be a different repetition.
No,
Here,
but
my
even
lord,
if subject matters are same, are you suggesting we
Right.
club all of them together?
no, my lord, here this
What kind of
on
submissions are you
on the same notification, there was a process for
So,
regularization
Just
of
a minute. You are
Fine.
submitting that this petitioner number 7 is seeking his appointment in the college represented by respondent number 10. That is already final. So his claim is become infructuous.
that, my lord, I will have to respond, my lord. I'll
You have
file
filed
my
an
notice.
IA.
Yes. That has not,
Is it
my lord,
IA listed?
it has not come with the record. IA has not been listed. It was filed on 29th, my lord.
Okay, it is submitted by Mr. B. Chetri, Learned Counsel, appearing for the respondents. Number 10. The claim of the writ petitioner number 7 vis-a-vis the respondent number 10 has become infructuous in as much as during the pendency of the writ petition, regular principal has been appointed by the college authorities. Respondent number 10, therefore, without a challenge to the fresh appointee, the claim of the writ petitioner number 7 vis-a-vis the respondent number 10 has become infructuous. In this context, the council submits that he has already filed an IA, which however is not listed today, raised to verify, raised to trace out and connect the IA from the WPC so and so and list it again after 1 week.
After
1 week.
the date maybe.
Date 10th August.
Lords. Okay.
Notice I am signing my Okalama today, and I have also received the instruction from the director that already a proposal of rupees 50 lakhs 46,085 rupees has been submitted to the government. Notice, and it is under process. So, notice, I am signing my Okalama today, and notice, can give it some time.
Mr. U.K. Goswami for the petitioner, Mr. S.M.D. Chisti appears on behalf of respondent number 1.
Yes, 1 and 2, director and secretary.
1 and 2.
Yes,
He submits that he has received it. the instructions to represent respondent one and file his power. Prays for 2 weeks' time to complete his instructions. 2 weeks,
Yes.
complete his instructions and price report. Release this matter again after 2 weeks on 21st August.
Apply zero.
Hello.
Regarding my lord, this my lord, first step was taken, my lord. Subsequently, as per court direction and the office note, my lord, it is reflected that the item is delivered to the address. Thereafter, my lord, another second step was done, my lord. And now, my lord, as per office note, my lord, 29.
As per office note dated 29/7/26, service report is awaited. Matter be listed again after 4 weeks.
My lord, as per my number of time this step was taken, my lord. And actually, my lord, as per my the postal
You have already taken steps.
Yes, my lord.
Right, so the record is there, so we'll have to give some time. Since you have already taken steps. Had you not taken steps, we could have passed the order.
2 times, my lord.
But you have taken steps.
Yes, sir.
The office has recorded that the AD card has not been received, so we'll have to wait. Can we presume service because you have taken 2 times, steps 2 times earlier? Not proper.
So, as per my information, my lord.
Then you should not have taken steps again. You have taken steps.
Yes, my lord.
Is it possible now to presume?
No, my lord.
That's what we are trying to tell. The matter be listed after 4 weeks, 3 weeks,
Date
24th August.
Justice, here the department has issued a compliance order.
That is not a compliance order, my lord. I know, I have gone through it, my lord, because it is
Let me-
against the order of the, let them file affidavit and short date may be given because this case relates to, my lord, opening the portal. The school was.
What is the direction in the order?
Yes, my lord, that direction is the opening the portal, my lord, as well as the lordship, because that I have obtained the order and obtained the order because this case is covered by 3224 2024, mother. That case also mine case, of course. And all these schools were opening the portal as well as the process is going on to provincialize the school. But now this case is covered by this case, my lord. Then now they would like to file a affidavit. And now he said that it is a compliance order. The 20 schools were already when the portal is opening. Now they would like to file affidavit in another school, which is similarly situated schools.
May I read the whole order of the findings and order, Lordship? Lordship, may I peruse this? One video.
Lordship will let them file affidavit so that I can reply it. A short date may be
Lordship.
given, 1 week time may be given.
The order, Lordship, having examined all the records, the facts in
And
place.
they have always played, my lord. In contempt case, I have seen that they bring compliance order, but they never supply to us before the listing the case, my lord. They should give it to
Yes,
yes.
yes.
Nothing, my lord. Nothing. Always they have done like
No,
this, my lord.
Lordship, I have
This
not,
practice is very bad practice.
Very
I have not, I have
I
not yet
totally agree
started
with you.
arguing, Lordship. I was supposed to, I have got all the photocopy, Lordship. I am supposed
but
to.
if you
Very bad. Very bad.
relying on
I'm
something.
sitting here. If you have been a supply to me,
Yes,
I
yes,
can
yes.
go to
I
it.
have all the copies with me, Lordship.
So you give it to her,
I am.
we'll defer the matter by 1 week. Let
Yes,
her go
my lord.
through.
Yes, yes,
Yes.
yes.
We'll
I
examine.
will argue.
You should, this is the practice, is correct. This is the practice one has to maintain.
Yes, my lord.
No, I have got all the copies, Lordship.
I'm
Yes, I am supposed to
this
give.
practice, my lord.
Otherwise,
I've
what is
never
the-
seen
the
this
part-
type of practice like that.
What is
my
the,
lord.
what is the
Very
point
recent practice?
what is the point of filing pleading if you are not sharing it?
No, I was supposed to give it, Lordship.
You have not
Are
given
we-
it,
still-
now you have given it,
Yes.
In spite of that,
and
And all the time we supply the copy to the other side, Lordship.
no, this is not correct, my lord, because I am suffering, my lord.
No, no.
This is not correct.
You have given it, we have deferred it for 1 week,
Yes, my lord.
and you'll ensure that you are also giving her a good cup of coffee.
Yes, Lord. So I'll have to in a break time.
Well, recently Supreme Court also tell that they have a respondent because of they never comply with the order, my lord, then the petitioner is bound to file the contempt of the case.
That's right.
So that my
That
lord,
is
yes, yes.
That is right. That is,
And
Recently
that
Supreme
is-
Court passed an
yeah, that
order.
that is something I have been trying to
yes,
urge upon the respondents that
Yeah.
petitions are disposed of with three months, 2 months, 6 months, but orders
Yes.
are never complied.
Never comply.
We'll have to find a way to ensure compliance.
Highly obliged, my lord.
Yes, next.
May I please, Your Lordship? I have the instruction to withdraw this IA also
IA for what?
for recall of the order passed in the arbitration petition.
Because they have already signed the agreement. ma'am.
Settlement has
Yeah,
been done,
they
Lordship.
have accepted
Deed
the
of-
amount also.
Deed of settlement.
As per the submissions made, the petitioner submits that the counsel for petitioner that the IA file is not being pressed. Accordingly, IA number so and so stands dismissed as not pressed.
Lordship.
And what about the petition?
Lordship, that is already disposed of.
That is disposed of?
Yes, ma'am.
Lordship,
Okay.
much of.
Yes, Mr. Chisti. 94.
So just Lordship, it is now the proposal is regarding amendment of a rule, Lordship. It is pending before the cabinet. So up to the instruction, I don't have Lordship, sir.
Mr. Chisti is permitted 4 weeks' time to complete his instructions, updated instructions, and place it before the court
Yes, sir.
in the next date of listing. Release this matter again on 2nd of September. 2nd September.
In 95, I sought Lordship accommodation because if upon enter record with him, he's suffering from dengue. So at least week or 10 days time, Lordship.
It is submitted by Mr. Chisti that the council entrusted with the records. Mr. A. Fupan is indisposed. He submits that the matter be deferred to be listed after 2 weeks.
Yes.
Prayer made is not objected to by the council for the petitioner. Relist again after 2 weeks. 19th. 19 August.
Apply.
Some typographical error. Para 8, 9, 11 and 12. It's relating to elementary education. Matter is relating to elementary education.
No, you filed the IA for what?
I for correction of the order.
Which order?
Dated matter the 29/5/2026 matter. Page 8 matter.
Yes, which part?
Part matter the paragraph 9 matter. Page 10 matter. Paragraph 8 matter. First.
There is no paragraph.
There is no paragraph matter, but
Paragraph numbers are not there.
My lord, kindly pass over time being.
He wants some correction of the order.
there is no number matter.
Then which paragraph?
Paragraph matter, page 10 matter, 1, 2, 3 matter. Mr. U. Sharma,
Yes.
Land Council appearing for Secondary Education Department matter. It should be Elementary Education Department. And the next paragraph matter, from the bottom matter, the second line. Director of Secondary Education. It should be Director of Elementary Education. And next, my lord, page 11, my lord.
Last para.
Last para, and accordingly, this court also grant in this paragraph, my lord, last line, my lord, inspector of school, my lord. Inspector of school, my lord, it should be district elementary education, sir, my lord, and director of secondary education should be director of elementary education. And last paragraph, my lord, the director of secondary education should be director of elementary education.
Where is Mr. Sharma? U Sharma. Please call Mr. U Sharma. Yes. You. Is there a copy of I available? You give him that copy, let him go through it. There are some corrections made, I think, in the matter where you appeared. You read it, we'll call up after some time. What is the I?
Modification of an earlier order, seeking an extension of the stay on the transfer order.
I have got my instructions, Worship. Perhaps the prayer made by the learned friend not be considered. As per the Worship, recollect the.
We'll call up after some time.
Yes, yes.
This is that series where your lordship wanted my learned friend to examine the jurisdiction issue, whether the deputy commissioner would have the jurisdiction to transfer teachers.
Yes.
There are two judgments of coordinate benches, one by Justice Ete and one by Justice Ukena.
Yes.
Yes, it is covered.
Covered. So what will be the effect of the order? Interfere.
All the transfer orders will have to go.
Which are the transfer orders?
Different orders in different cases.
We'll need a chart.
Date-wise chart, my lord, in each of the petitions. I appear in, my lord, except three items.
Not only in your matter, all the other councils, if they agree,
Yes.
then we request all the council for the petitioner to give a chart, supply it to the standing council department, get his concurrence and furnish it to the court master today.
Yes.
During the course of the day.
Well,
Heard.
your lordship will just require the dates of the orders.
No, no. With regard to each writ petition, which is the interim, which is the impugned order.
One.
Each writ petition.
Yes. Because it all are.
Number with date. Item number and date.
And where is the liberty granted this order?
That liberty they will always have.
For liberty for?
For
Issue fresh transfer.
Huh?
For issue fresh transfer order.
Why should we give you
Only,
liberty?
my lord, my lord, because the order has been passed by the district commissioner instead of the officers of the education department. Only on that ground, my lord, that has been interfered with a liberty to pass a fresh order of transfer.
Where is the order of the coordinate bench?
In publication number 400/2026, order dated 25/3/2026. Operative part as paragraph 19.
18 and 19.
They will not give you liberty. Why you want liberty?
Since your lordship, my lord.
Liberty is when the same authority wants to pass another order. We are setting aside, we are holding that the district commissioner does not have the power. Any authority who has the power may issue. Why
Like, my
liberty?
lord,
Is required?
that was done on, that was not the pleaded case of any of the writ petition, my lord.
What?
The deputy commissioner,
In our case, we have taken the.
See, we are
plea has
asking,
been taken by filing an
therefore we are-
additional affidavit.
therefore we are asking.
After passing of this order, madam. After passing of this order, my lord, in one case,
they have filed an additional affidavit taking this ground.
It's a question of law. Jurisdiction is a pure question of.
But you are not, that therefore we asked you to go through the order and tell us if this is the order we want to dispose it of. If you agree, we dispose it of. But what we are saying is that the liberty is not required. Even if we don't give it, you have liberty because this is issued by somebody, some other authority.
Right.
Giving liberty is inviting the authorities to pass another order in
My
the
lord,
same line.
in the order, which is, my lord, relied upon, my lord. However, since the interference of the impugn order of transfer of the petitioner is only on the ground that same was issued by the district commissioner without jurisdiction and authority, the respondent authorities are at liberty to pass fresh order of transfer if so advised.
You are otherwise at liberty.
Yes, my lord.
Why do you want that rider from the court?
Since, my lord, your lordship, on the basis of the order passed by
We
the
are
court,
taking the principle, the ratio in the
Yes.
orders. We pass an order in the similar lines,
Right.
but no liberty. We are not saying there is no liberty, but we are not giving that rider. Dispose.
Right.
This will be item numbers
39 to 74.
39 to 74.
In fact, my lord, except 39, 63 and 64, I appeal, and 69 to 74. Other matters I appeal. So we'll give a consolidated list.
Dispose.
May I be proceed? Proceed. Yeah, in this case, I am appearing for 76 and 77. So we have sent the affidavit for vetting, Lordship.
You sent it for vetting.
76 and 77.
In fact, another case today was not listed.
No, 75? Who's appearing in 75?
It's the beast of property, man.
Where is he? These are all connected.
All
Connected
connected,
matter. In fact, one connected matter not listed today. That is arbitration petition 36, man. The tagging order
So
actually
we
was
listed
wrong,
after
right?
1 week.
Hello.
One person may not receive.
This is a
8 to 10
appointment,
months have gone by
11-6. What objections are you giving?
He wanted to say that there is a conciliation provision. But
We'll
the
list it
conciliation
on-
is not mandatory.
We'll list it on 12th. 12th August. Matters be listed on 12th August on the request made by the council of the Planet CGC that they are taking steps to fight their objections. So Mr. B. Pathak submits that these matters be listed. That are, what is the other matter?
Arbitration petition number 36.
The arbitration petition number 36 of 2025 being similar may also be listed along with these matters accordingly. Arbitration 36 along with these matters be listed on 12th. The respondents may file their objections, if any, in the meantime.
Apply.
Page 175. Lordship, that amount where they to appoint list of the arbitrator so that we can sue them. Everything is complete, mine. Page 175.
Lordship may close the matter with a direction to specific time. They will provide the list
Direction to the authority to
to name the arbitrators.
Name the arbitrator.
okay. So why have you filed 11-6? Why did you file 11-6?
Yes, proper appointment of arbitrator, my lord.
Then
That we have already completed all the formalities. They have asked me to submit the item-wise claim. as per the page 175, we have also submitted it.
Right.
But they have not given the who will be arbitrator, how they will be appointed, how I can choose one of them.
No, you are agreeable to choosing an arbitrator named by them.
Yes. No, I am not agreeable, but they have to give a 3 or 4 persons names who will be arbitrated.
Then you will decide whether you will choose or not.
Oh, yes. I may not choose it.
Then we are dismissing the petition now.
Who will be arbiter, I don't know, my lord.
Then what? You come back later.
So they have asked me to submit the item was claim. Accordingly, I
You are
submitted.
filing this under 11(6).
Yes.
If you are agreeable to an arbitrator to be nominated by the respondents, we are closing this petition. There is no requirement for the court to appoint an arbitrator. You are yet to give your consent. You have not given your waiver.
Yes, yes, Lord.
It is submitted that by the petitioner that the item-wise details have been furnished by the petitioner. However, the respondents having accepted it have not given the list of arbitrators respect of for appointment. It is only upon the list being furnished that the petitioner will decide whether he would like to concur on any of the arbitrators from the curated panel maintained by the respondents, or he or he would choose not to waive his right for appointment from the curated panel. And in that view of the matter, since the petitioner expresses a possibility of appointment of an arbitrator from a curated panel maintained by the registry, by the respondent department. At this stage, the claims of the petitioner by way of the 11(6) petition for appointment of an arbitrator is premature. Accordingly, the same stands dismissed, giving liberty to the petitioner to approach the court at the relevant point in time if so advised. Interim orders, you can stand with it.
Lordship, I'm on behalf of Mr. ABT Hawk. He is inside hospital emergency with his father. Lordship, matter may be taken after.
Yes.
Item number 79.
What are these matters?
These matters are regarding old pension scheme and new pension scheme. The petitioner claiming order that says their process of appointment was prior to 2005. So as per the government notification.
Where are your appointment orders?
There are separate, the petition we have next.
Your claim is that the process was initiated before 2005, but appointment orders were initiated later.
No, my lord, actually, the petitioner was earlier, my lord, there is schools and colleges, my lord, provincialized in 2013. So they were working in the private school and colleges side to it.
Your colleague is indisposed. You want all the matters to be taken up together. Prayer is made on behalf of Mr. ABT Hawk that he is unavailable to come to court because of medical emergencies in his residence. Therefore, prayer is made to have the matter listed after 2 weeks. These matters will be listed after 2 weeks, 79 to 81. Mr. P.P. Dotto will respond. Any objections you want to file? No objection.
Let it pass, my lord. My only prayer is, my lord, Honorable Justice Mr. Anuma Adega may be, my lord, appointed as an arbitrator.
But the petitioner is not here, it's their petition.
That is the problem.
None appears for the petitioner on call.
My lord, let it come up after 2 weeks. In the meantime, I will also, my lord, seek and my lord, whether if they want to file, my lord, I'll file an objection.
Listed again after 2 weeks. Enabling the respondents to file their objections, if any. Mr. Chaudhary appears for the respondent.
I'm diplomat.
Kindly change the order dated 27/4, Lordship. Getting some area salary.
Lordship, in this matter, Lordship, I have received a partial instruction, Lordship. It's not a completed one, Lordship. Kindly allow me 4 weeks of time, Lordship. I will, Lordship. I had a communication with the department. Lordship.
Yes, Mr. Khan.
4 weeks is long time, Lordship, because other petitioner has already, Lordship, got the relief and the amount has already been released in their favor.
3 weeks.
At least, Lordship.
2 weeks, Lordship.
3 weeks. 3 weeks maybe not that, Lordship.
The date may be.
2 weeks maybe.
Mr.
too
N.
less,
Khan,
Lordship.
counsel for the petitioner, Ms. N. Sharma.
And M. Sharma.
N.M. Sharma for standing counsel. Secondary
Lordship.
education submits that instructions are not complete. She pays for 4 weeks' time
Lordship.
to complete her instructions. Mr. Khan on the other end objects to the prayer made in the sense that matter being pending, the matter being listed again after 3 weeks. Considering the prayers made, matter being listed again after 3 weeks on 28th of August.
But in this case also, Lordship, their affidavit will require.
Lordship, we will file, Lordship. I have received.
Same order,
Lordship.
same date.
Lordship.
Chief petitioner is assistant teacher or in charge is assistant teacher, Lordship. Presently also he is a charge, and the impugn order is 47 Lordship.
Impugned order is at
47 Lordship.
47.
Lordship.
Yes. $47.
Lordship.
The instructions haven't come in as yet from the EDC.
My lord, I'll make a small submission. The fight is between, in respect of taking as the in charge HM between me and him. So it is in the district level. Otherwise, the real authority is the director. So I think over here in this case, your lordship may refer the matter to the director to decide who will be the eligible for holding the post as a in charge headmaster.
Yes.
I think that will be better.
This status quo may be maintained.
Who is holding charge now?
I'm petitioner is holding.
Petitioner is holding charge.
Though, my lord, actually, in otherwise, he is not even a graduate. Nowadays, my lord, graduate to be either DLEd or B.Ed is necessary to hold that post of headmaster. That is the basic education. If he doesn't have that requirement, then he cannot become an in charge, because the person to become an in charge, he also has to have to fulfill the required qualification. He doesn't have the qualification. So I'm not into it, my lord. Suppose if otherwise the authority is the director. Let the director decide, my lord. Whoever is in otherwise out.
petitioner is
Within a period of short period, my lord, let him carry on. I am not disturbing that, my lord.
Yes, what do you say, Amit?
Or I could have said, my lord, DEO can take over the school at in the meantime.
No, they are saying that matter be decided by the director.
Lordship, Lordship.
You have filed some representation
Yes,
before the director.
yes, my lord.
Where is that?
My lord, I have not. I'm just first day appearing, my lord.
You are appearing today.
Yes, my lord. Let the director take the call afresh and decide, my lord.
Yes.
in the meantime, I may be protected.
Heard counsel for the parties, petitioner will vote serving as
Tutor.
tutor. In which school? Kawadanga ME Madrasa.
Lordship.
Now it is a school.
Now it is school, Lordship.
He was initially appointed as in Kawadanga ME Madrasa, which has subsequently been renomenclatured as Kawadanga ME School.
ME school.
ME School.
Lordship.
It is merged.
Lordship.
Merged or a separate entity.
Madrasa's name has been changed.
No, my lord, all the madrasas now nomenclature is school.
School, but it is not merged.
No, not
Not
merged,
merged.
not merged. Same institution.
By order dated the services of the writ petitioner was provincialized. Your service was provincialized.
Lordship.
Yes, ma'am.
As a tutor,
Along with R6, my lord.
along with the private respondent. And the petitioner joined the said school, Kawadanga LP School, as a tutor with effect from 8/2021. Thereafter, one Jafidur Rahman was allowed to look after the academic functioning of the school, stop to which the writ petitioner filed a complaint to the District Elementary Education Officer, Dorong, stating that he, being the senior teacher, had been discharging functions as the in-charge headmaster of the Kawadanga ME School, as it then was, as a madrasa, as per resolution of the SMC. And therefore, the decision to allow Jafidur Rahman to be in charge of the headmaster was assailed, prayer was made that the same be recalled. Stop. Thereafter, the petitioner was allowed to hold charge as in charge headmaster of the said school until further orders by order dated 6/3/2026 issued by the District Elementary Education Officer, Dorong, Mall. Stop. Thereafter, by order dated 11/3/2026, the Additional Deputy Commissioner Education, Dorong, again passed an order allowing the respondent number 6. 6 is it?
Yes, my lord.
To hold charge as the in-charge headmaster of the said school on purely temporary basis. deference to the said order, the PEEO, Dolgaon, Sialmari Education Block, Dolgaon, by order dated 21/5/2026, directed the petitioner to hand over charge of the in-charge headmaster to the private respondent number 6. Being agreed, the petitioner is before the court. It is submitted by the council for the petitioner that he is the head teacher and therefore he is the under the provisions of the rules, he is authorized to be appointed as the senior most teacher. Therefore, he is authorized to be appointed as the head teacher or the in charge headmaster of the so school. Stop. There are Mr. Abedin appearing for respondent number 6. On the other end, submits that the petitioner does not qualify to hold the charge as he is appointed as a tutor.
No, it doesn't have the basic qualification to hold the post of
It
headmaster.
does not have the basic qualification to the post of headmaster, which the private respondent number 6 has, and therefore he was given the responsibility to hold charge of the post of the headmaster, which order has not been complied with by the writ petition. So, its contentions of the counsel for the respondent is denied by the counsel for the petitioner. The state, represented by MSS Kumar, appearing for the education department, and MSS Sharma appearing for the deputy commissioner, submits that instructions are awaited. Stop. Considering the submissions made and upon perusal of the pleadings available, seen that under the provisions of the Assam secondary education, what is that rule? Under what rules? Assam secondary education, provincialized service rules 2017, 2018. Where is that rule?
That is page 99 of that book.
99.
But my lord, after the provincialization, the school falls under the category of the normal.
So what rules govern? That's what we are asking you. What are the rules under which the decision is to be taken by the authority? Your what rules? Your what school is that?
ME school.
ME school. Is it under 77 rules?
Yes, my lord.
77.
Some secondary schools.
Well, it should be the Assam Elementary Education Provincialization Rules 1977.
Some elementary education provincialized rule 1970.
Yes.
Assam Elementary Education Provincialization Rules 1977.
But the procedure for promotion to the post of headmaster, that is in page 318 in respect of ME school, etc. my lord. But, changed.
Rules for elementary education, yes, studying council, which rules are governing?
77 rules, Lordship.
So point out the provision where
So Lordship, page number 318, Lordship. Procedure for a promotion to the post of headmaster of ME and ME school, Madrasa ME. This is 2nd March 2010.
where are the qualifications?
But the basic
You are government aided,
now provincialized.
so that does it make you government aided? Are you governed by these 1960 rules?
My lord, I believe that after the provincialization, the school automatically comes under the elementary provincialization rules of 1977. And this notification is running the field, my lord.
And 318.
318.
First one.
Post of headmaster of any schools.
My lord, as per procedure, best, my lord, present procedure, because
Huh?
as per present procedure, because now under the NTC has come in, NCT has come in, my lord. Now the basic qualification, earlier it was the high secondary, now the basic qualification as on date today, it has to be
Was
graduation.
under what provision it is there? None of you are able to point out.
This is the notification holding the field.
So if it is the notification, it will be covered by this notification. Post of headmaster is to be filled up on a promotional basis of the seniority cum efficiency and recommendation of the district level selection committee.
Lordship, this doesn't. Paragraph 9.
Yes. The district level selection committee is to be comprised with the members as specified under section 3, Roman 5 of the Assam Elementary Education Provincialization Rules 1977. Selection, procedure and appointments specified under clause P6. Yes, what is the judgment?
Lordship in paragraph 9, Lordship. Then
Yes.
Then there is a notification dated 2nd of March 2010, number A, so governing the procedure for promotion to the post of headmaster of ME school, MEM, and senior basic school, clause 1 of the said provided the post of headmaster ME for senior basic school.
See the notification, page number 318.
Yes, yes.
Accordingly, the matter now stands remanded back to the Director, Secondary Elementary Education to take all steps necessary for filling up the post by way of regular headmaster by following the procedure prescribed under the rules. Read with such memorandum of notification as may be valid. Stop till such a decision is undertaken by the Director and procedure is adopted to select proper candidate, the petitioner continue to hold charge as the in-charge headmaster, subject to there being no proceedings initiated against
My Lord, only one thing that may be done within that period of,
the entire exercise be undertaken within a period of 4 months.
no, my Lord. When I was given the charge, the next day he was given, I handed over the charge. But when he was asked to give the hand over the charge, but he's not,
3 months. 3 months.
let it be 1 month, my Lord.
1 month it is not going to happen. We are going to come back with a contempt.
I think it's a small issue, my Lord. Who among us?
We also think it is a small issue, but it doesn't get resolved.
Still, my Lord, let us try for 1 month.
The entire exercise be completed within a period of 60 days from the date of receipt of the copy of this order.
Deeply obliged.
Yes, Mr. Sharma?
Yes, in this matter, madam, S4 appeared for the elementary education department, and
So
I
it needs
was,
to be corrected.
yes, madam, definitely.
All right, heard counsel for parties. This IA has been filed seeking correction of the order dated 29/5/2026, passed in WBC 5810, 5180 of 2025. Learned counsel for the petitioner has pointed out the corrections which are required in the said order. Stop. The counsel for the respondent does not object to the same. It is seen that these corrections will not materially alter the order. So, rather, these corrections are essentially corrections of syntax. Stop accordingly. In the order dated so and so, the third paragraph of page number 10, word secondary education department be replaced by, be read as elementary education department. In the fourth paragraph at page 10, the director secondary education be read as director elementary education. And in the second paragraph of page 11, inspector of schools be read as the district elementary education officer. Of which district? Dibrugarh. Dibrugarh. And the director of secondary education be read as elementary education. Elementary, director of secondary, director of elementary. And the fourth paragraph at page 10, so the director of secondary education be read as director of elementary education. this order be read together with the order dated so and so, past in WPC so and so. I accordingly stands allowed this.
My lord, in this matter, in page 10, paragraph 3, instead of use Sharma, my lord, it should have as core, my lord. She was the counsel.
That we are not going to say. Because it is a petition filed for application filed by him.
Yes, yes.
Doesn't make a difference.
Yes.
May I please, your lordship? Your lordship, may I kindly peruse the earlier order at page 22.
Page
Page 22.
22.
Your lordship's direction, your lordship's.
Surgical procedure.
Lordship, that thereafter, your lordship, page 24 onwards, your lordship, in the group hospital, I started taking.
No, but now you have to definitely tell us that how much time is
Your
necessary.
lordship will kindly see, come to page 35, your lordship. I was referred to GMC, your lordship, since they don't have a gynecologist, your lordship. At the bottom, your lordship. Operation postponed due to low hemoglobin, uncontrolled blood sugar, and generalized weakness. Patient required medical optimization for surgery to reduce perioperative risk. So, patient is rested in the 45 days because of weakness of patient. This was the advice by the University GMC, Assistant Professor, Department of Gynecology. And this is dated, your lordship, 21/7/2026.
You show the medical opinion. There is a medical opinion which has come from the composite hospital.
Lordship. That's his ethic serial number Roman 3, your lordship. It is there, but this is that hemoglobin is required, but I don't have that, your lordship. Now I will have to leave it to the your lordship. Only I can show only this, your lordship. This is by the GMCH authority. Now they say that it is not required, and
What is not required?
no immediate intervention, your lordship. That is as per the aforesaid opinion recommended as offered by the Board of Medical Officers constituting so and so specialist. Then it is quite clear.
The operation is postponed because of these conditions.
Lordship.
So these conditions you'll have to control it and then go for
That is what your
operative procedure.
That's 45 days time.
So that 45 days time you don't have to spend here. You can go and join in your place of posting, get it controlled, come back. Or get it done there. There must be a composite hospital. Where are you transferred?
Lordship, I am transferred to your lordship, Lucknow. Husband to Punjab.
Must be there.
Lordship. If your lordship can accommodate us for 45 days more, your lordship. I have to leave it to your lordship, but your lordship may kindly see my condition, your lordship.
No, your condition is there.
Lordship.
Either you go on sick leave.
Lordship.
Whatever provisions are there, you go for medical leave.
Lordship.
It is rejected, you come before the court, we'll see what can be done. But these conditions which are there,
Lords.
these are conditions which according to the surgeon, you are not fit to be, it's not a case of, what do you call, emergency surgery or anything like that. So for the surgery to be undertaken, these conditions are required.
Lordship, that is what, if you
As per the medical reports. Now, if you think that you need more time, can this be a ground to stay or transfer?
no, your lordship, that is why your lordship, I am only pointing it out, your lordship. The last order, your lordship, about speaks
This
about
was given on 21/7.
21. Now, your lordship, we are
Now,
today
even if we defer it by 10 days or so, it will not improve.
45 days, they say.
45 days from,
They say.
then again,
That is not a guarantee that.
and
In fact, your
it
lordship,
does not say that there is no facility in your place of posting.
that your lordship, I don't have the knowledge. Now, your lordship can kindly see that this is a hospital, your lordship, group hospital. There is no gynecologist here. That is
I would humbly submit, lordship, the statement is not correct. The board of,
and
the
they
board
themselves has
board
referred.
consists of a gynecologist.
Page 29, your lordship will kindly see. They
You get an
themselves have
opinion from a gynecologist there. Ask her to present
lordship.
in the composite hospital.
Refer to GMC for further evaluation. Your lordship.
That is for the evaluation. lordship. Now,
That is what your lordship, they could not.
it is not the
Therefore,
case where there is no gynecologist. Now, here is a case of transfer. Now, if she goes to the new place of posting, it is not that there is no hospital out there. There is a composite hospital there. It is there every place. And right now she is on duty. She is doing her duty.
yes,
She's
without
doing her
arms.
duty. If it is possible to, we don't know if she wants to undergo the surgical procedure here.
That cannot, it cannot be an option. I want to do it right here.
No. It is an option if the medical conditions otherwise permit. So therefore, if there is a gynecologist in your group hospital, you get an opinion.
That is the last paragraph says.
This.
The last paragraph says.
Okay. Consisting of gynecologist.
Yes.
There is a gynecologist.
Lord. I have been my instruction is that whether she belongs to here or not, that I don't know, your lordship. But my instruction is that in the hospital she was told that they don't have the guy.
No. There is a reference
And
here.
if it is possible, your lordship will kindly see 2 months that has already been elapsed with us. Now, if it can be accommodated for another 45 days, and ultimately it is she belongs to this place.
See, after 45 days, you'll undergo a surgery.
Lordship.
There, as a post-operative case, you'll be not allowed to travel for another 30 days at least.
Lordship may kindly see your lordship. She will be in Jalandhar.
We are not here to decide on that.
No, that is not. It is only on humanitarian consideration. I am before this honorable court.
Humanitarian is all right.
Lordship.
It
It is not that your lordship, in my absence, everything will be stalled, your lordship.
No, you take leave. Who's
Lordship,
stopping
that
you?
is-
You have enough leave.
Lordship.
Go and take leave. Medical leave. Why you want it under the court's order?
This is
Tell us.
no, your lordship will kindly see that 2 persons. I have in my family, my husband, wife, and 2 minor children, your lordship.
Not a
One
ground,
will
sorry.
be in the Jalandhar, one will be in Lucknow, your
Not
lordship.
a ground.
Now, your lordship, they have asked me to. Ultimately, I will have to be somewhere along with my
policy
family.
for husband and wife, spouse on the same place of posting?
That in the writ petition we have already annexed that policy, your lordship.
That is that overnight.
Lordship, overnight journey. And Jalandhar and the
How is it overnight from
12
Jalandhar to
hours,
Gauhati?
your lordship.
That was not a case which was presented. Writ petition, my friend only argued on the medical problem.
Okay, one is transferred to Jalandhar. Who is transferred to Jalandhar? Husband.
Husband to Jalandhar and the petitioner to Lucknow.
Lucknow. So between Lucknow and Jalandhar it is a overnight journey.
They say overnight 12 hours.
12 hours is
12
overnight.
hours.
On the basis of the medical condition, lordship had allowed the petitioner to remain here.
See, they are your employees. You have a composite hospital. You have said, all right, this is what is the finding. Give her a proper medical advice. There is no medical advice that whether it is necessary, not necessary, do it now, do it after 3 months.
No, Lordship, she was suggested and she declined. She declined at the initial stage. So it is there.
There are two.
Yes. She declined at that point of time.
In 25
Yes.
and in February 26. Then you have declined.
No, Your Lordship, 1-year-old child is with me, Your Lordship. How can I, Your Lordship? There is a reason why I have declined. It is not, Your Lordship, all along I have been complying, Your Lordship. It is under compelling circumstances I have come.
You have challenged the transfer order. We have granted you as far as practicable.
Lordship.
But the question of stretching sympathy beyond the
No, Your
particular
Lordship,
period,
will kindly say. Had it been a case, Your Lordship,
unless you tell us that no, this is not a ground for transfer.
fact, Your Lordship, in the order itself, Your Lordship, it was reflected that the board has noticed that on the earlier occasion, petitioner has refused to undergo surgery which the learned counsel for the petitioner submitted was because of the tender age of the child. That has been recorded in the earlier order. It is not that, Your Lordship. And Your Lordship, I would have, Your Lordship, had this medical condition not been there, Your Lordship, I would have gone, Your Lordship. There is no question about it. Since this honorable court has directed, I presented myself and I wanted to have the surgery, then the doctor says, that expert says that 45 days will be required, Your Lordship. And that is why I am before this honorable court, Your Lordship. Now it is for Your Lordship. If Your Lordship feels that this is not enough, Your Lordship may pass an order, Your Lordship. Otherwise, Your Lordship, it is only on that. Two children, husband will be in one place, Your Lordship. I will have to be operated, Your Lordship, with my 2 children. How can that
You examine whether there is a possibility of posting them in the same area.
Lordship, that will also help me.
Jalandhar or Lucknow,
Lordship.
considering the medical condition.
They can file an application.
No, you find out.
Lordship.
We'll order it. Find out if it is possible, available there or not. Or if you want them to file an application.
I will file, Your Lordship.
It's a provision under the rules. No, but Lordship will consider, Lordship, this is not a case which is projected in the writ petition.
No, but it's not denied by you.
Lordship, here is a case where your Lordship had.
No, the question is whether she is required to undergo surgical procedure or not. It's not denied. Medical report says she is required, but because of certain health conditions, not now.
Now,
on these conditions, and then
now whether my friend will agree to the proposal if it comes, if husband and wife are posted in the same place.
I will agree, Your Lordship.
They will be.
I will agree. I have specific instruction on that.
Lordship will record.
third counsel for the parties, the petitioner, the applicant is an employee of the CISF, or PRPF. PRPF was under orders of transfer to be posted at Lucknow. By the transfer order dated 14/1/2026. So this order was initially there was an interim order. This order was put to challenge in WPC number 1783 of 2026, wherein initially there was an interim order done. So subsequently, the matter came to be disposed of, directing the respondent authorities to accommodate the petitioner for a further period of 2 months from the date of disposal of the matter, which is 1/6/2026. The petition was accordingly disposed of. Now the IA has been filed seeking further time on the ground that upon the petitioner being examined by the composite hospital, she was sent for further information. further examination before the GMCH. And the GMCH has given a medical opinion to the effect that because of certain medical conditions of the writ petitioner, where is it? Medical?
Page
Page
35.
35.
That she's suffering from low hemoglobin, uncontrolled blood sugar, generalized weakness, etc. Medical optimization is required before surgery to reduce perioperative risk. And so the patient was advised rest for 45 days. This opinion was rendered on 21/7/2026. It is on the basis of this opinion that the IA has been filed seeking an extension of the period granted by this court while disposing of the writ petition by the order dated 1/6/2006, WPC 1783/6. Mr. R.K. Dev Chaudhary, learned DSGI, assisted by MS L. Devi, has placed before the court the medical opinion of the Chief Medical Officer of the composite hospital, CRPF. Stop. In terms of the state medical, the following conditions are reflected, clause 1, 2, 3, and last 3. Under these circumstances, appointed query made by the court, the respondent to the petitioner, to the applicant, as to whether she will be agreeable to transferred and posted in the same place with her husband. She agrees that he submits that he's on instructions to accept such a transfer if granted by the respondent's parent. Mr. Chaudhary, on the other end, submits that you will have to obtain instructions. Submits that the matter be listed after 1 week.
It will be on Wednesday.
Wednesday. Listed on Wednesday. Accordingly, release this matter again on Wednesday for instructions for Mr. Chaudhary to apprise the court on the instructions received. List accordingly.
Problem.
Here in this matter, as per the last order, the department was directed to place its records. The record is not available. May pay for some accommodation. The record is necessary.
When can you do it?
After 10 days,
Mr. D. Upamanu, Standing Council, Higher Education.
Yes, sir.
Submits that the records called for have not yet been received. It prays for 10 days time. Call for the records and place it before the court for perusal. Prayer made is not objected to by the counsel for the petitioner, as also by the counsel for the respondent. Release this matter again after 2 weeks. 19th, 21st August.
But I have an interim order in this.
Interim prayer, if any, granted earlier, will continue till the next date of the stay.
May I please your worship? In this case, your worship, the petitioners here in your worship are all your worship.
Affidavit filed.
Affidavit filed, your worship is
Post deposited. There's a post
Before that.
you have deposited.
Yes. Before lordship. On or before their lordship.
Okay.
Accordingly, we have.
Before that you have filed. Very nice. Now
kindly come to para 10 of the affidavit.
there are 10.
We are aspirants for appointment as a graduate teacher. Your worship.
Yes, para 10.
The department did not appoint any candidates from general area against Hindi teachers vacant posts. The proposal letter has been submitted.
Yes,
The proposal letter has been submitted for approval for appointment to the post of assistant teacher, art, science, Hindi, Sanskrit, by office memo number so and so dated 12/13/2025. The proposal was made for both recommended candidate from BTR and non-BTR as per the minutes of the council level selection board meeting held so and so in resolution number 7 indicated in part 1 BTR candidates and part 2 for non-BTR candidates. The BTC authority has approved for appointment of category of part 1 BTR candidates by letter number so and so. Now this
you are non-BTR.
non-BTR and they have, your lordship, although selection committee has forwarded the names, your lordship, they have
Not accepted.
not, that is not there, your lordship. What has happened in the meanwhile, your lordship, election was declared and probably for that reason it got stalled, your lordship. Now it is
Is
pending
it
at
possible
this
that
stage.
Yes,
subsequent decisions are taken?
sir. This I have over telephone lordship. Finally, yet not come somehow lordship.
Your
In the
lordship
meantime,
has
if
directed
direction given,
complete the process within
complete
a
the process,
specific
that
period
may,
of time.
that may be lordship. Your lordship.
Since selection committee has already, your lordship, from the same selection, one part has been appointed, your lordship.
Third, learned counsel to the parties. The petitioners are all graduates in Hindi
Lordship.
with
Uh,
BA
Sanskrit.
degrees.
No.
In response to an advertisement dated 13/2/2024, issued by the Directorate of Education (BTC) for filling up of posts, vacant posts of graduate teachers in different subjects, including Hindi, in different provincialized secondary schools. Under the Directorate of Education (BTC), the petitioners responded to the said advertisement and offered their candidatures. So they were called for a written test, which they appeared, and upon successful completion, they were called for document verification. Stop. After due completion of the document verification, the concerned authority published a selection list of candidates belonging to the Bodoland Territorial Region on 17/6/2025. So, however, so far as the candidates belonging to non-BTR areas, the authorities have not published the select list. So, being agreed, the present petition has been filed. Pursuant to issuance of notice, the respondents have BTR. You say BTR or BTC?
BTR.
Huh?
BTC is approved.
BTC
BTC is
has been filed, where there is a clear averment at para 10, which reads as under para 10 to extract. The council for the BTC submits that the process has not yet been completed. The competent authority was in session of the matter when the elections were declared. State assembly elections were declared, because of which the work could not be completed. However, if the direction is issued, then the same shall be completed within the time specified. Mr. S. Pothakur, Senior Counsel, assisted by Mr. S. Day, appearing for the petitioners, does not object to the suggestion made by the counsel for the respondents. So, submits that the writ petition can be closed with a specific direction to the BTC authorities to complete the process of selection, and appointment to the in which is undertaken by the BTC authorities pursuant to the advertisement dated so and so. Stop. While the select list for BTR area candidates have been published, the select list for the candidates from the non-BTR area respect of the teachers is yet to be published. Stop. They are considering the submissions made, and upon hearing the counsel for the parties, and also suggestion on the suggestion and also as agreed to by the counsel for the parties, the writ petition disposed of with this direction to the respondent authority, more particularly the
Respondent number 1 to 3.
respondents 1, 2 and 3, more particularly respondents 1, 2 and 3, to examine the claims of the writ petitioners and thereafter conclude the process of selection and appointment undertaken by the BTC authorities in pursuance to the advertisement dated 13/2/2024 for filling up of vacant posts of graduate teachers, including graduate teachers for the post of Hindi in various schools, in various provincialized secondary schools under the BTC area. Stop. Let this exercise be expeditiously completed within a period of
3 months.
3 months from the date of receipt of a certified copy of this order. Needless to say, once the process is complete, the authorities will publish all necessary orders and select list and inform candidates by making publications locally circulated newspapers disposed. Reply not right. Yes, who's the department? Secondary education. Secondary education. You are under suspension.
No, sorry, I was attached and removed from this in charge principal.
You are removed.
We have a interim.
There's an interim protection.
Yes.
The respondents will apprise the court as to whether the inquiry undertaken against the writ petitioner has been concluded. The respondents are permitted 2 weeks further time to complete their instructions and place it before the court. Release this matter again after 2 weeks. Interim order passed earlier will continue.
This
Mr.
attachment order
Dr.
has
appears
been
for the
removed.
secondary education.
This is the attachment order, Lordship. As per this Honorable High Court order dated 1710, that Abhiday Aspin has already been revoked. This attachment order earlier. Anyway, Lordship, I'll place the copy.
There is some stay order.
Lordship.
For orders, I think 91.
Yes.
This case, they have filed affidavit and reply, Lordship. The last week. So, matter will be taken for
Pleadings are exchanged.
Pleadings are
Matter be listed for admission. After 2 weeks. Mr. Dotto appears for the
Secondary.
secondary. MS.
And on behalf of division.
I want to. Similarly, similar matter.
Similar matter. Where is that order again?
Page 38.
Page 30. Page 30. Okay. Similar.